Hello, everyone. Welcome. I'm Timothy Endicott, and I'm delighted to welcome you to this exciting event. It's part of our Oxford Public Law Book Festival, and there'll be more celebrations which you can find on our website. I'm ever so grateful to Hayley Hooper and Lord Newburger for agreeing to come and talk about Jack Beatson's wonderful book. Hayley is fellow in law at Harris Manchester College and came to Oxford from Glasgow for the BCL and never looked back and did the doctorate in law in Oxford. And Hayley works on the principle of legality and on the nature of a doctrine of political thinking in public law adjudication and on national security. And so it's all in Jack's book. And those are some of the reasons why she's here.
Recording in progress.
Could I suggest that I don't know how to mute everybody, so I wonder if I can ask you to mute yourselves if you're able to. That would be great. And David Newburger, he has an interest in the issues in Jack's book too, and Jack's book has an interest in what he did as President of the Supreme Court of the United Kingdom from 2012 to 2017. And so I'm particularly happy that both of them are here to talk about the book. I'm going to say something very brief about Jack and the book, and then I'll hand over to Hayley, and then to David, and Jack will have an opportunity to reply to what they have to say. And then we plan to leave plenty of time for discussion. If you haven't read the book, don't let that stop you. And I will invite people to use the feature on Zoom that allows you to raise a hand. That'll give us a cue, and we hope that lots of you will have an opportunity to weigh in. And if we all weigh in very briefly, I'll have questions too if I get a chance. That'll give Jack more time to tell us what he thinks. There's a charming point in Jack's book, The Rule of Law and the Separation of Powers, where he mentions Lord Bingham's approach. And who wouldn't read Tom Bingham's book, The Rule of Law, when you're thinking about the issues that Jack works on in the book? And he points out the list of considerations that go to make up the English idea of the rule of law. And he mentions that Sir John Laws had one focal idea in mind in his understanding of the rule of law, which was the independence and impartiality of the judicial institution that's authorized and required to impose objective standards on the use of public power. And Jack Beatson points out that you can see the approach of a historian. Tom Bingham was a Balliol historian in his work, and you can see the philosopher. John Laws was an Exeter College classicist and had studied classical philosophy, and Jack uses that frame to understand the approach of these terrific predecessors and Jack is working in a tradition of thinking of which John Laws and Tom Bingham are really important elements. Well, Jack Beatson was a Brasenose undergraduate lawyer and studied jurisprudence. So of course he's a student of history and of philosophy and of law and of the cases. And on the rule of law, he looks at the forest the way a good forester looks at the forest, with a concern for each of the trees. And as a result, the book is a treasury that I recommend very highly. Now, Jack, having studied jurisprudence at Brasenose, went on to be a fellow in law at Merton College and became the Rouse Ball Professor of English. One of my university, Oxford University's contributions to understanding is the tradition that you can see in Jack's successors in that chair, David Feldman and today Louise Gulliver. and his predecessors, David Williams and William Wade. Oxford has trained these people either as students or as colleagues in the law faculty. And Jack is part of that tradition of contributing to enlightenment in Cambridge. He went on from being Rouse Ball Professor of English Law at Cambridge, and having served as law commissioner and as a member of the Competition Commission, he went to the bench and served as a Lord Justice of Appeal in the Court of Appeal. And so he brings the erudition of a Brasenose lawyer and the scholarship of a Cambridge professor and the hard work of a Court of Appeal judge to these issues. And I'll tell you a difference between his book and Tom Bingham's book. Here's one difference: the title. And I think it's rather important and elegant the way Jack approaches the rule of law, thinking at the same time about the separation of powers. Here's another difference, which will be evident to many who are here. 10 years since Tom Bingham's book, The Rule of Law. What a remarkable era in the development of the law by the judges. And I'll cut to the chase. What I find in Jack's book is a virtue, an attitude that he calls circumspection, the approach of the judge to working out the judge's own responsibility for the rule of law, working out how to discharge the responsibility for the rule of law in a way that respects the separation of powers. These are the things that I love about the book, and I hope I get a chance to ask some questions that I have for Jack. But I'm going to hand over now to our panelists, to Hayley Hooper and to David Neuberger for their comments on the rule of law and the separation of powers. Hayley.
Thank you so much indeed, Timothy, and a huge thanks to Jack for writing such a wonderful book. I have about 15 minutes talking time, and my plan for that 15 minutes is to outline some of the things that I really enjoyed about the book, and there are many things that has many virtues. I saw some different things in it from Timothy, so hopefully that will be valuable. And then I've got 3 kind of comment or discussion points that I want to bring up that I hope that I could have some further reflections from Sir Jack upon, because I understand it takes a huge amount of time, energy, effort and talent to write a book that's this concise and this detailed, and obviously some things have to be left on the cutting room floor and other things have simply been developments since the book has gone to press. So first and foremost, I think it's a really important book, and I think the thing that's most important about it in the British constitutional context is that it doesn't put parliamentary sovereignty front and centre, which is obviously the temptation when you're talking about the British constitutional order or the British legal system. We think of parliamentary sovereignty as being the bedrock or the foremost principle, but it takes on what I would call the 2 little sister principles in the rule of law and the separation of powers. So from the get-go, I think it's adding something to the literature simply by doing that. It also is quite, although it is very much circumspect, it's quite forthright in its argument and pushing back against a trend that's maybe traceable to Dicey, but it's certainly been re-emerging as a trend in the context of the Judicial Power Project and the maybe some other scholars that are here present, like Professor Endicott, and that's the idea that the government can act without recourse to law because it has an inherent power for the public good. And I think that's a myth that the book seeks to dispel, and I think rightly so, because it's one that's potentially quite dangerous. The other thing that I think it does that's really important is that it shows that the principles of the rule of law and the separation of powers are not exclusive to, let alone owned by, public lawyers. And I think when we're in law schools working in intellectual silos, it's quite tempting to kind of claim them as our own, but they have important ramifications for the legal system as a whole. And the book really brought that home to me. It deals really extremely well with the principles themselves. It offers concise and clear statements of the principles as concepts, but it also deals incredibly well with the realities of how these concepts play out across the legal system. I'll give you a few examples of which. I think are really important and really make points that are useful and valuable in the overall debate, which is voluminous, as everyone here knows today. So, for example, any decent definition of the rule of law, running from form to substance, if you believe in that distinction, suggests that laws should be open, general, accessible, clear, and forward-looking. But Sir Jack's book points out that even in this day, in the 21st century, we have large bodies of law in the English and legal system of England and Wales that remain highly complex and inaccessible to the public. This is despite the fact that even though we've had large-scale reforms like legislation.gov.uk and the British and Irish Legal Information Institute, which was a huge innovation, and this is a view that he shares with the House of Lords Constitutional Committee. He also makes the point, which is of deep rule of law concern, that intelligibility is becoming a particular issue in the criminal law, and he seizes upon this quotation by Lord Gough at page 38, which I thought was particularly apposite, that the common law is, I quote, a mosaic that is kaleidoscopic in the sense that it is in constant state of change in its minute particulars. His analysis of the separation of powers is similarly forceful, showing that it is an important principle, but it really is the third principle in the pack. Sir Jack says that save for the independence of the judiciary and the power of the courts to supervise the legality of acts of government, our constitution has not recognised the separation of powers as a discrete constitutional principle, and that is part quote, part paraphrase on my part. The book also brings home something of the unreality of the separation of powers, in that Sir Jack's analysis forcefully points out things that we often forget. For example, that it's Parliament that does confidence and supply and the executive relies upon it. And that the government at the end of the day funds the legal system, so we might have judicial independence on one level, but it's certainly not a principle that runs all the way down. And finally, he points to the analysis of Lord Reid in Unison, the landmark case on access to justice decided by the Supreme Court in the last few years, where Lord Reid points out at paragraph 68 that it's the interrelationship between these three grand constitutional principles, the rule of law, parliamentary sovereignty, and the separation of powers, that really gives life and effect to the principles of constitutionalism. And finally, I think what's really important, and this is connected to one of my earlier comments that the book does, is it raises that the ongoing concerns we should have about executive dominance in the Constitution. Sir Jack says that the fundamental imbalance between the executive and the legislature in our constitution is one of the reasons for increased recourse to the courts. And he says that this imbalance was not redressed by any of the reforms since 1997, i.e. many of New Labour's statutory reforms like the Human Rights Act, the Freedom of Information Act, the Constitutional Reform Act 2005, and many others. And this goes against the quite celebratory grain that some other leading academics have had about New Labour's reforms. So this is an exceptionally valuable book. I commend it to you. Whether you are a dyed-in-the-wool public lawyer, a practitioner, or someone who's entirely new to our legal system, you will get something out of it, and I commend it to you thoroughly. Moving on, I said that I would bring up three discussion points. My first of which is developments in parliamentary sovereignty by the courts. So I think the book goes to great lengths and properly so, to show that the Dicey concept of the Constitution, which is very much descriptive in kind, has become very much outmoded in our present constitutional landscape. And I think there is great force in this, particularly with respect to three recent decisions of the Supreme Court. Unsurprisingly, I have in mind Miller and the Secretary of State for exiting the European Union, Miller and Prime Minister, and the more recent decision on the devolution reference relating to the UN Convention on the Rights of the Child bill from the Scottish Parliament. I know there's lots of controversy in this, and we could argue about this all day, but I think it's fair to characterise the ratio of the first Miller case, that the common law holds that you cannot have fundamental constitutional change without parliamentary consent by way of primary legislation. Similarly, we see an even more normatively robust development of parliamentary sovereignty in Miller and Prime Minister, where the Supreme Court unanimously held that the executive could not frustrate parliamentary sovereignty or parliamentary accountability by proroguing Parliament for an excessive length of time. And more recently, in the UN Convention on the Rights of the Child Bill, Lord Reid held that devolved legislation which risks opprobrium to Westminster contravenes the ability of the Scottish Parliament to make law within competence. And that's quite a claim, so I'll read out exactly what he said at paragraph 52. He said, a declarator of incompatibility under Section 21, the bill purported to replicate the Section 4 Declaration of Incompatibility mechanism we see in the Human Rights Act, would be a judicial finding that an Act of Parliament is incompatible with those obligations. The possibility and a fortiori the actuality of such a finding would plainly affect the Westminster Parliament's power to make laws for Scotland, since it would impose pressure on Parliament to avoid the opprobrium which such a finding would entail. So my question for Sir Jack, and maybe for the audience more generally, is do any of these cases go too far in articulating the normative content of parliamentary sovereignty? And could you have any further reflections on where we draw the line on normative articulations of parliamentary sovereignty so that they don't bump up against the other constitutional principles that are so vital to the functioning of the system? With that in mind, I want to turn to the principle of legality, and I share Sir Jack's view that it is both a principle of statutory construction and a deeper constitutional principle. And it's indeed very, very important, because Sir Jack points out that because of parliamentary sovereignty, Parliament can freely legislate contrary to rule of law values like legal certainty, for example. And one of the ways in which the common law ostensibly puts the brakes on this is through the principle of legality as articulated in the Sims case, which I assume will be familiar to many, if not most of you, so I won't articulate. However, this type of legality has come under some trenchant criticism recently, most recently by Professor Varujas, in a quotation that was seized upon by the government in its response to the independent review of administrative law. Professor Varujas suggested that there is an emerging preference on the part of the Supreme Court for developing and applying the principle of legality at the expense of more established grounds of substantive review. Similarly, the outgoing Lord Chancellor, Lord Buckland, suggested in a speech that the principle of legality had taken on a life of its own. I want to propose an alternative view of the principle of legality insofar as I think it's become not a runaway standalone principle, but it's recently been the victim of excessive contextualisation. I have in mind three cases: the Dolan case challenging the Coronavirus Act and the secondary legislation made thereunder, the Third Direction case, known as Privacy International and against the Foreign Secretary, and the Coughlan case, which was a challenge to the pilot scheme for voter ID piloted in a local election. These are all recent Court of Appeal cases in which principle of legality challenges failed. In the Dolan case, it was held that there was no general or ambiguous words that would cause the principle of legality to bite. And this comes despite the widespread use of executive power, including the creation of criminal offences with minimal parliamentary scrutiny. In Privacy International, which was a challenge to the policy known as the Third Direction, it's a policy that purports to authorise criminal conduct by either the security services themselves or persons working on their behalf. The Court of Appeal called reliance on the principle of legality a rather paradoxical argument, because the policy purported to authorise criminal conduct to protect against the taking of innocent life and to inhibiting the activities of those having no regard whatsoever to any principle of legality. And finally, the failed challenge to the pilot voter ID scheme, Coughlan, is not drawn on whether the right to vote is fundamental. The court is not drawn on whether this is a fundamental right at common law, despite the fact that the pilot scheme was made by ministerial order. The court rejected any legality challenge. And of course, now we have before Parliament a wider proposal for voter ID, which I will comment more in a moment. The Electoral Reform Society have suggested that this risks disenfranchising 2.1 million people who don't have access to the necessary ID. So my question for Jack is, how does he see the principle of legality developing? And should we be concerned in particular that the common law does not protect access to the franchise with the same ferocity as it protects access to justice? And finally, I want to end my comments with a commentary about something that I call abusive constitutionalism and where we might be at in terms of the presence or indeed absence of abusive constitutionalism in the United Kingdom constitutional order. So abusive constitutionalism is a term coined by Professor Mark Tushnet at Harvard, and I will offer the definition that he gives to contextualise the question. So Professor Tushnet says that abusive constitutionalism describes a situation in which the hallmarks of liberal constitutionalism are dismantled by ostensibly legitimate means. Changes occur using constitutionally permissible methods and are usually numerous and piecemeal. Taken individually, they are innocuous, but as a package, they threaten the liberal constitutional order. So my question is that, given that we're witnessing the potential repeal of the Fixed Term Parliament Acts, independent reviews of administrative law and the Human Rights Act, proposals for voter ID in general elections, reforms to the Electoral Commission, which represent a potential risk to its independence, and widespread legal aid cuts, are we potentially in a phase of abusive constitutionalism? And if so, do we have robust enough concepts of the rule of law and the separation of powers to countenance such developments? I'm going to bring my comments to a close here, and I reiterate in the strongest possible terms that this is an excellent book worthy of everyone's attention. Thank you very much indeed.
Thank you, Hayley, for those dynamite questions, which Jack will get to after Lord Neuberger.
Thank you very much. Like Hayley, I think that Jack has produced a terrific book, and it covers a lot of ground in a very readable and clear way, and gently challenging. It well worth a read, and stands very well next to Tom Bingham's book. I think that Hayley has raised some very significant questions, and tempting though it is, I will try not to go over the same ground as her, but I have to say that a great deal of what she says, almost all of it, I think, I agree with. The rule of law is, to say it's under attack is a slight overstatement, but there are causes for concern about it, as Jack has commented on and dealt with in his book. I think many of the threats come from government, in the sense of the executive. The two topics which get a lot of coverage at the moment with the problems in the economy are COVID and Brexit. And I think they have also led to issues which impinge on the rule of law. Although I don't go nearly as far as my former colleague, Lord Sumption, I do think there are aspects of the way the government has treated the law when it comes to COVID as being of concern. My worries are more to do with the way that, either intentionally or out of ignorance, there's been a confusion in the message between what is guidance and what is law. And there's been confusion, either intentional or out of ignorance, as to when a law actually takes effect. So we've had ministers whom the public is entitled to expect to tell them the law as it is, telling people that what are merely recommendations are the law. And as we saw initially, at any rate, the police acting on the basis that guidance was law, and fining people for failing to observe guidance. And we had government saying that such and such was the law when it hadn't yet come into effect. I think there is a serious worry among some of us that our politicians are not interested in the rule of law. I recall when I was president of the Supreme Court, I thought it might be a good idea to invite MPs to come and have meetings with us in the Supreme Court with the justices to discuss how we saw things, and in I hope not a patronizing way, to educate them at least in the way that we saw the rule of law and what it involved, how the Constitution works, no doubt hoping that they would tell us how they saw things. And I mentioned it to the then Clerk of the House, Robert Rogers, now Lord Lisvane. And when I described what I had in mind, he said, it's an absolutely excellent idea, but there's one problem. And I said, what's that? And he said, none of them will come. And I think there is a lack of interest in the Constitution and in how things work from the legal point of view among politicians. And no doubt they would see judges as being obsessed with it, but I think that is a problem. I think another problem arising from Brexit has been the Internal Markets Bill, which fortunately was abandoned, but where the government was proposing not merely to break its international commitments, to break international law, but to ask Parliament to approve of this in a statute, in effect. And unfortunately, the House of Commons agreed, but the House of Lords, where the pressures, political pressures, were of course much less, held out, and in the end it was abandoned. But I have a nasty feeling we were at risk of seeing it in relation to a similar approach in relation to the Northern Ireland Protocol, which hopefully maybe we may see the back of that particular problem at any rate. I think another aspect slightly differently, which Jack touches on in the book, more than touches on, is the ending of the traditional Lord Chancellor. I can quite understand why it was felt that the Lord Chancellor in the old style should go. And it would be, I think, quite unrealistic and probably even undesirable to expect it to be returned, to be reinstated, the old Lord Chancellor system. But it did mean that there was a forceful person who was listened to and prepared to speak out in the cabinet and out of the cabinet, who was a member of the government and a member of Parliament in the House of Lords, who would speak up for the rule of law and for the independence of the judiciary when it was needed. And of course, after Miller won, we saw the problem with not having a Lord Chancellor of that type. And I think we suffer from it today. It is easy to identify the problem. It's very difficult to know of any solution, an obvious solution, it seems to me, but one which I suspect is quite unrealistic to contemplate, is for the Lord Chancellor to be somebody who's appointed by an independent body, albeit in a member of the cabinet. But the idea of the Prime Minister giving up the right to appoint the Lord Chancellor appears to me, unfortunately, to be a little short of fanciful. It's fair to say that in terms of the Constitution being under attack, the complaint of judges being frequently attacked by the press and by the politicians appears to me to be a very overstated problem in this country. It may be that I will look back on what I've said in view of what happens in the future with regret or embarrassment. But looking back over our time, over my time in the law, there have been very few attacks of any substance from the press. The part of the shock of the enemies of the people headline was that it was such an unusual event, and it hasn't been repeated. Politicians from time to time do attack the government, do attack the judiciary, but when it has happened in the past, even under the new Lord Chancellor system, it has not been a sustained or repeated attack from particular ministers. And I think we should acknowledge that as being a benefit of being in this country. And of course, one hopes it continues. One of the topics that Jack touches on is constitutional statutes, which is a matter of some interest to lawyers. In the end, it can be said to be a point which doesn't go that far, because in the end, it seems to me that a constitutional statute ultimately is one which is not, whose provisions are not impliedly repealed by a subsequent statute. And one wonders whether a constitutional statute goes much further than that. At the moment, I suppose the question is who decides what are constitutional statutes? And in that connection, it is the judiciary, because nobody else takes on that task, and it's judiciary initially through the late lamented John Laws, who developed the idea. But there is a view, I suppose, that is the judiciary taking on itself the role of deciding whether Parliament intends or did not intend to impliedly to repeal a statute. In my view, that is properly part of statutory interpretation and consistently with the principle of legality, which Tracy touched on, is an important and fundamental, Haley touched on, I beg your pardon, which is an important factor, a very important factor in our law. In my view, the principle of legality cannot be overstated. It is a fundamental rule. And at a time when, as I say, regretfully, parliamentarians don't seem to be particularly interested in fundamental legal principles or constitutional principles, I think the principle of legality is very important. Because it's so important, it's not surprising that ingenious lawyers try and invoke it in order to support their cases, as often without success, as Haley has said. But that is one of the penalties of having an important principle. So far as where we've got to in terms of human rights, judicial interference with government and so on are concerned, I think we have to bear in mind that for 50 years, the judicial preparedness to get involved in decisions of the executive has increased beyond all measure. That is scarcely an original thought. But with Annis Minnick in 1968, Tameside in the 1970s, GCHQ in the 1980s, the Human Rights Act in the 1990s, the Constitutional Reform Act and Freedom of Information Act in the noughties, and the upheaval with Brexit in the last decade, previous decade, just past. The involvement of judges in public affairs, to put it in the broader sense, has increased enormously. There are those commentators who have seen in the past year the Supreme Court as pulling back to some extent from that attitude in cases such as Begum and BM Eritrea and SC. Whether that perception is right or not remains to be seen. But if there is an element of consolidation after 50 years of what has been almost breathless development, that is scarcely surprising and not necessarily a matter for regret. I think there are different sorts of case where the courts may hold back a bit more than they did before. Cases involving what might call socio-political issues, it may be that the time has come to reconsider where we've got to and to regroup. But on cases where the courts have stepped in to stand up for Parliament against the executive, in cases such as Miller 1 and Miller 2, or for the courts against the executive in cases such as Evans and Privacy International, without saying whether those cases are right or wrong, it seems to me that on that, the courts should not be stepping back, but that is performing a classic constitutional function. And perhaps it's a measure of the political situation we've got into in the past decade that so many significant cases of that sort have had to be decided. At any rate, those are a few thoughts on my part, and I hand back to Tim.
Thank you so much, David. Jack, it's over to you, but I can only hand over to you with an apology because I told you before the event that you would get to say something about the book before we subjected you to Haley and David. So now the floor is yours, and please do, as you see fit, tell us what you would like to get off your chest about the book, as well as about what Haley and David have said. Jack.
Yes, well, thank you very much, Timothy, for organizing it and for the introduction, and David and Haley for putting together their probably over-generous comments. Two of the book's earliest readers were friends. One was a distinguished professor of politics, and one was a distinguished legal commentator whose work is probably read by many of you. They were very positive about it generally, but in slightly different ways they chided me, because they felt I hadn't produced a message to a wider audience about desirable reforms, the lessons I draw from my perspective as a former academic, a law reformer, a judge. And so I was a bit sort of, taken aback. I think actually many of the people whose names I see on this call will see where I'm coming from. Hayley saw where I was coming from. I can see Paul Craig's face on the screen. I think he knows where I'm coming from. But perhaps the reason that some, particularly non-lawyers, can't find a message, because I have a very strong belief, notwithstanding the notable recent example that Lord Neuberger has referred to, that judges and ex-judges have to be very careful when commenting on sensitive issues. And there is no shame in being nuanced. And because if you don't do that, you risk damaging the perception that the judiciary is impartial. And the oddity is that seems to apply even when ex-judges make these comments. You might think that once you're free, once they've handed the king's shilling back to the king, you can do what you want, but it's not like that. And anyway, I think that the other reason they couldn't find a clear message is that I do think that Lord Gough's kaleidoscopic comment was true. We have a subtle and complex scene, and painting that in the vivid colors of Technicolor risks distorting that. So my defense is, one, I shouldn't do it, and two, it would oversimplify it. And I may just be a reflection of my generation. I think my message was that the subtle and complex arrangements we had, certainly between Ridge and Baldwin and GCHQ, but after that, provided the safeguards that all say they want, without imperiling the proper balance and the primacy of the democratically accountable parts of government. Now, some, my former colleague and friend, Stephen Laws, for example, might think that's a sign of complacency. He would say that, wouldn't he? But I recognize that some cases go too far. I've teased Lord Neuberger, although he was not in the majority on that the Bank Mellot case, in which Lord Sumption took what might be called a very, very expansive view of judicial review on a matter where national security was at stake. And an American friend of mine said, oh, well, he was just protecting his friends in the city, which I think is a bit unfair. But some cases go too far, some cases don't go far enough. And I think for myself, the one bright color that I have is about restricting access to courts. I know everybody thinks that the proposal in the courts and whatever it's called bill, the one with dealing with Lord Folkes's judicial review proposals about CART, that's all right because it's a very small thing. But I do think that restricting access to the courts is very dangerous. The courts mustn't aggrandize what they do, and they're in danger of losing ground if they do. And that may be one of the arguments, one of the responses to one of Hayley's questions about substantive principles. But I do think that if you don't have a court as the final arbiter, where Parliament has not been clear, or where Parliament where there are different values involved, then you do get to what I think John Laws referred to as executive sovereignty rather than parliamentary sovereignty. And we know, let us look, we heard the budget over the weekend. That would never have happened under our constitution. Parliament is sidelined in many, many ways. And I think that growth in the executive's general domination of the Commons, doing things by press conference rather than in another way, I think those are changing the focus of the Constitution. And one of the things that I think they've been, and I don't discuss this very much in the book, one of the consequences of that is I think that the self-restraint which marked the executive's exercise of its own power is lessened by that centralized control with people who like going to Castle Barnard and who are not very keen on Parliament. And so I think that's my thing. Now that's a bit of a ramble. That's the price that Professor Endicott has to pay for taking me away from my text. Ramble, incoherent ramble. Haley's questions. I myself do see the Miller cases, and I put them in the book together with cases where there is a arbitration between central and local government, where the courts say, no, this was for local government, not central government. No, this was for central government, not for local government. Cases like Tameside on education and other cases like that. So I don't think, I think Miller 2 may be, paradoxically, Miller 1 was the one where there were dissentients, but Miller 2, in a way, I think may be the one that is nearer the line. In the end, I think, partly because of the way the government played the game, without any explanation, and left open the possibility that you could have a 2-year prorogation, which the courts were supposed to then say, well, it's not for us. And once you don't have a conceptual line to draw, it's there. And I do think that that case was the nearest to the line. I think David Neuberger has referred to soft law and guidance, and we can add to that Henry VIII clauses. There are many other ways we have of bypassing Parliament. And I think that in the end, the defense of the courts is that although in the end, Parliament can bring a government down, the party system and the way it is managed in this country means that is not a reality. And so even when the Speaker, for example, I'm just reflecting on what's happened this week, the Speaker rants about the Chancellor of the Exchequer revealing the details of the budget and not doing what Hugh Dalton did in 1949 and resigning. There's very little control over all of that. And so one has to ask where the balance is going to come from. Now, I do say, and I hope that if you look at the book, I can't do it I do think that there is a great danger that if judges go too far, as Lord Scarman said in a trade union case in the 1980s, then the public will be willing to cut back the power of the judges, and then they will be less able to do justice in the way that they do now, and they will be more restricted by the law than they need to be or they are. So I am quite worried about the stress testing that we're subjecting the rule of law to. We can't really say that the separation of powers is being stress tested, because it is, as I forget whether it's Haley or David said, it is the weakest of the principles, other than the independence of the judiciary. But I think that we've relied on conventions and self-restraint by everybody, by the judges, by the executive, and by parliamentarians. And we've and presumably we've also relied on restraint, thinking about what's going on in Sudan by the army. The danger I see at the moment is that all this stress testing puts that restraint into question. And because our constitution is so amorphous, unwritten, matter of convention, then it's very difficult to see how it's defended. It depends on the acceptance of the people. I'll finish by coming to the principle of legality. Jason Varujas' critique of it and saying that legalities applied at the expense of more substantive principles has a reflection in a fairly recent Supreme Court case, where Lord Carnwath resisted consistency becoming a principle of you. He said, no, we've got proportionality, we've got legitimate expectation, we don't want consistency. And so I think that the principle of legality underpins these other some more substantive principles. It's not a reason for the fact that it's not quite the same as them. It's not a reason for discounting it. And yet, at the end of the day, it's a principle of construction. And so we get back to the question that David Neuberger asked, which is just how rigorous the courts will be in reading down statutes. And the answer to the question that Haley asked is that I don't know, because at the end I accept, I mean, we all must accept that the principle of legality is a principle of construction. If we accept parliamentary sovereignty, we accept parliamentary sovereignty. The courts, I think, want the legislature to be clearer and clearer the more entrenched they are. And I agree also that there'll be a difference between powers about socio-political matters and personal liberty. But on the other hand, we also see great stress testing of rule of law and access to justice values in cases where we have closed procedures justified on national security grounds. I myself think that if adequate protections can be found, then you can justify departures from the basic rules. The question is, can they be found? And we see the cases show tremendous differences, and you see differences between judges on that. I mean, Lord Kerr and Lady Hale, for example, were much less warm towards the ability of the system by matters such as special advocates, etc., to balance the matters. So I think that's all. That's the end of my ramble. I'm grateful for the comments, but I think we must. I would say at the center of it all is access to the ordinary courts.
Thank you, Jack. And it may well be that Haley or David will have something to say, but I'll ask them to wait, and I'll wait, and offer participants in this event the opportunity to ask questions. On my screen, it says reactions at the bottom right, and if you click on that, you'll see a hand, an icon allowing you to raise a hand. And if you can do so, I'll form a queue of those who would like to ask a question. Could I say, it's very helpful that you've all muted your microphones. You're more than welcome to turn on your camera. It's lovely to see you. It all depends on your circumstances, of course, but that'll be nice for the rest of us if you choose to turn on your camera. And there's a question from Philip Sales.
Hi, Jack. As you know, I really enjoyed reading the book. My question arises out of your comment just now that because our constitution is so amorphous, it's hard to see how it is defended. And I wonder whether you had any recipe as to how the court should proceed in circumstances where they have to deal with a rather amorphous set of legal principles and then fashion some determinative norm to be applied in the case at the end of the day, and how that can be done in a way which commands respect for the court's neutrality and impartiality. And as a sort of sub-question, would you favour a written constitution in order to give positive rules which the courts could point directly to and satisfy the public that we're simply applying the law as it's been written down?
I've spent all my time as an academic wondering whether I favoured a written constitution or not. I don't actually think that we have our structures don't lend themselves to that. We find it difficult to pass. We find it difficult to pass consolidating legislation, bringing together all the law on the environment or other matters. So I think I would, if we'd had one, I would think that was good, but I just don't think we will have one. And there are prices. We can look at the United States at the moment, and we might say that if you've got a constitution and things are stuck, it might not be so good. In fact, it was always said when I was a youngster that the reason that the American courts were far more activist than ours were, I mean, Schwartz and Wade wrote a book which effectively did this, that because the Americans had a constitution and so they couldn't do things legislatively, so the courts had to do it or it wouldn't get done. So I think that I'm probably an agnostic, if not an atheist, on a written constitution, because I just believe we would have, it certainly would have to be one that wasn't written by the winners. You know, you get one party in power, so you get the Fixed Term Parliament Act, and then you get a different party, so you abolish it. You have to have something that's created with people of different views. I actually, going back to the other question, I think that the crab-like tendency that our courts showed of taking one step and seeing the reaction, and then if it seemed to go too far, taking a step back, I think in a way that had served us quite well. And it has allowed us to react to contemporary needs and contemporary feelings. And I have no other. It's up to people, it's up to you. And I saw Mike Fordham somewhere there. It's up to people like you to do it now. I'm just an observer.
Thank you, Jack. Haley mentioned in the chat that that we're recording the session. We'd like to put it on the university's website, and it's worth keeping that in mind. Alison Young has a question.
Thank you, and thank you, Jack, for your book, your excellent comments, and also to Lord Neuberger and Haley for their great questions and comments. I'm just picking up on something towards the end of your comments when you talked about the fact that maybe if courts were faced with a situation where judicial review was being completely undermined, that might be one of the situations in which they should push back in order to ensure there are effective checks and balances. I also wondered what you thought about a situation that might arise if you thought that the right to vote was being challenged in that fundamental way as well. We've seen that, for example, in things like prisoner voting in Muan, which is not a major challenge, but a kind of nipping at the edges of who should be able to vote. But what if we saw more substantive challenges, perhaps picking up on some of Haley's comments about the measures that are coming through in the election bill and the consequences that they might have? Do you think that's an area where the court should also feel willing to kind of have a stronger pushback in those scenarios in order to protect democracy?
I think that in the case of the right to vote, there are, and I deal with a little bit of it, and I must acknowledge my indebtedness to Hayley on this, because it was her article which alerted me to the Scottish case, the name of which escapes me now.
Muhan.
Muhan. That's it. I think that there are 17th century and 18th century routes which would allow the courts. See, when you talk about pushback, that instantly raises questions of legitimacy. There are, I'm not allowed, but I think I'd say there are principles in the past that would allow us to, that may need more articulation because of the pressure that's being put on the value that those principles protected. So if that's pushback, then perhaps, but very cautiously.
Can I jump in with a question, Jack? And it's of course related to what we've been talking about. On page 137, you point out the way in which our political system enables a party to secure a 100-seat majority in the House of Commons with 42% of the vote of the electorate. And you say these figures and the ebbs and flows in the fortunes of parties over the past 100 years provide support for the view that it is legitimate for there to be a legal or political break, B-R-A-K-E, on the power of the party that is in power for the time being. I wanted to ask you, what about this break that they're competing in that electoral system that creates a strong majority, which of course is completely subject to the House of Commons. You say earlier in the book that the executive controls the House of Commons. Certainly the strong executive that we have has remarkable powers that it can exercise without needing the House of Commons. But does it control the House of Commons? It seems to me the House of Commons controls the executive, and the parties are in competition, and while they're in power, they face a political need both to fight the next election and to sustain support of their own party in the House of Commons. So it strikes me those are valuable breaks.
Well,
Why is that enough, and what more do we need?
Well, I suppose that my point is that the growth of the party system was one thing, and collective cabinet responsibility was another thing. But the move to prime ministerial power, I myself don't get the feeling. There's a lot of that Parliament is in fact the backbench members of the majority party are not generally a very good break. I may just be wrong on this, but I just don't see it. I mean, people want jobs, and people also, there's an issue about loyalty, and lots of things are done without going to Parliament. And you know, when I was a judge, I saw lots of decisions and things done which, when they were challenged, the challenges failed because one applied the law. But there was some there were some very strange things, and particularly, so I don't myself see the members of the majority party who are not such a high proportion of them have jobs. The payroll, I forget what the proportion is of the payroll, but I don't see them as a very good break. We effectively have except on something like the Internal Markets Bill, we have a unicameral system where the Lords just give up. And in the Commons, we have as we have.
Thanks. And I mean, perhaps the need to keep the confidence of the House and to win the next election is good for some purposes other than others in giving us responsible government. Can I ask you about Henry VIII clauses in particular? I mean, I think it's a bit mean to Henry VIII because the Statute of Proclamations didn't enable him to do some of the things that government can do under enabling legislation today. It's just remarkable. And certainly the political need to have power in the House of Commons doesn't serve as a brake on the use of Henry VIII clauses. Do you have any suggestions, Jack? Can the courts perform any kind of a general braking service to the nation on Parliament enacting provisions that say the government can do it as the government sees fit?
Well, I mean, I think that the difficulty is that you have sovereignty and you have a quite weakened sense of the non-delegation principle when it is legislation authorizing something. And I think I give a couple of examples of, and maybe this is against what I've just said. I give a couple of examples under the Legislative and Regulatory Reform Act in 2006, which was empowered the amendment of any legislation to reduce any burden to ensure that regulatory functions were carried out in a transparent, accountable, proportionate, and consistent way. And that, in the end, was pared down a bit, but there was a great outcry that it would have allowed a minister to curtail jury trial by order and things like that. And I think if a minister tried to curtail jury trial by order, then it may be that the courts would use the principle of legality to cut it down. But as I also say, there's no sign no sign that government accepts the criticisms of the attempts, criticisms of doing this, or that they'll try and wean themselves off it. They quite like having the MPs really as social workers for their constituencies' problems, and clever people in the ministries will make the laws. The whole pressures of putting in place structures for the complicated future relationship now that we've left the European Union and for dealing with the pandemic shows that there's been a significant, the temptation is just to do it with Henry VIII clauses. So I think that you could, if the courts tried to get more robust in this area, the reaction would be, as the reaction is by some, to what was done in CART. I don't think there'll be a special, it may be that there should be a special approach to preserving legislation in Parliament, just as there should be a special approach if there are restrictions on the right to vote and the franchise. But it's difficult to see conceptually how that would happen. And there's less of a history of that. There is the case of proclamations, and there is all of that. But I do say that between 1888 and 1929, there were eight Henry VIII clauses used. And in 2010, the Ministry of Justice estimated that there were about 120 passed. And that's before we got to Brexit and the real need for massive legislation, undoubtedly needed. That's before we got to the pandemic. So I just don't see that there's an appetite to move away from those things. So if the courts have to worry about their legitimacy, I think that it's going to be more difficult for the courts to do more than they're doing. If you look at the cases on these powers, it's not the area where the courts have been most active.
Thank you. Now, I saw a hand raised, but I apologize. I can't see your name. If you'd like to, you're very welcome to go ahead. I have another question, but I'm going to ask Hayley and David if they had anything to follow up on before I.
No, this is Jack's day, so I'm quite happy to stay quiet. Thank you.
I just would like to say that I entirely agree with Jack's analysis of the relative strength of Parliament as against the executive. I think the only circumstance where Parliament really does have power to stand up to the executive is in circumstances where the government hasn't got a majority. And we saw that after Mrs. May's 2017 eletion. But once the government has a significant majority, then it's the power of the executive vis-a-vis Parliament is much greater. And the need for the courts to step in is all the more important where the executive, to control the executive when it doesn't act appropriately. The other thing I wanted to say was I've always been interested in Miller 2. I can't comment on Miller 1, I was in it. But Miller 2, like many people, I think, many lawyers, my initial reaction was to think it was unjusticiable. But the more I looked at it, the more I thought that it was justiciable. And I thought that the decision of the Supreme Court was unanswerable, actually, both on whether there was a jurisdiction and on the facts, how it should be exercised. Well, that's what I want to say.
We'll never know because he's far too discreet. But the interesting thing is when you've got Lord Reid dissenting in number 1 and clearly being a major player in the unanimous decision in number 2, in Miller 2. Well, I like to give Cherry her role in this, Miller and Cherry. I think, I just wonder whether he thought it was different or he was following a precedent that Miller 1 established something about the balance between the legislature and the executive and avoiding Parliament. And so he followed it. We'll never know. We can speculate because I don't think he'll write in the Daily Mail or have Piers Morgan interview him when he retires.
No, I don't think he will, but I do think that the extent of this disagreement between the majority and the minority in Miller 1, I will say this, is easy to overstate. There was no dispute between us as to the principle and the role of Parliament and of the executive and the powers of Parliament and the executive. The only difference turned on the interpretation of Section 2 of the European Communities Act, which Robert Reid, in his very good judgment, said did give the executive the power to serve an Article 50 notice, and that turned on his view of the construction of Section 2, and it's a view which the majority, including me, didn't agree with, but it was a powerfully argued view which some academics agree with. But there was no difference of principle between any of us.
Timothy said, and I've quoted him in the book, that Robert Reid was unanswerable.
Yeah, there are those who have that view.
Yes, it's one of those questions on which the views on both sides can be that the matter is unanswerable.
I found in my time as a judge very few cases were unanswerable, but that's perhaps more a question of temperament than anything else.
I used to say when I was a youngster and people wanted to know why I was hesitating on a line, and the great giant in administrative law those days was H.W.R. Wade in his pre-knighthood phase. And I used to say, if I could be as certain about anything as Bill Wade is about everything, life would be so wonderfully simple. And I think these are really difficult questions. And coming back to the question about whether we should have a constitution, of course, giving a constitution, once you've got a text, helps take it away from the persona of the individuals dealing with it.
Well, since you've raised it, I feel perhaps more strongly than you, having oscillated about it, that a constitution probably is not a good idea. I think it would take 15 years for a committee to report on our constitution. And the chances are, like so many carefully thought out recommendations, it would be too controversial to introduce. And it is quite dangerous to introduce something into a system which is alien to it, just because it works in other places. And in the end, as we've seen in so many countries with constitutions, they can be subverted. They're not a guarantee to sound government. And I think it would require an extreme state of affairs before we should think about changing our constitution so fundamentally by having a formal written constitution.
Can I support David by telling a joke? Are jokes allowed, Timothy?
Yes.
In the 1980s, I was invited to go to give the keynote speech at a conference in Korea. Korea had had a very strong man as a president. His name was either Park or Kim, one or the other, whatever you want. And he was stepping down, and the ruling party didn't have a stronger figure to replace him. And they were worried because the opposition had a sort of charismatic, strong figure. So they started to see the attraction of prime ministerial systems of constitutions. And this conference, which claimed to be by a university, was actually organized by the party, was about whether prime ministerial or presidential systems are better at protecting individual rights. And I was asked to write a paper, and I was asked to send it to the university in advance. And there was a fax. I sent it on this paper by fax. And I got onto the plane giving the keynote speech at this conference, where my theme was, it really depends on the political culture. You can have prime ministerial systems which are very helpful to human rights and other ones that are not, and vice versa. And I gave examples. And when I got off the plane at Seoul, I was taken by one of the organizers who said, we had a change of program. And I was giving a side talk in a side room. And the lead talk came from a German professor of administrative law called Kaiser. And he said, well, he said, we had a presidential system. But basically what he said was that that presidential systems were less good at protecting democracy and human rights. And he gave the example of the rise of the Third Reich of Germany since the war. And the audience, in the Korean part of the audience, which is when I realized they were all from the party, all clapped that. So I think tinkering with the constitution is really dangerous, and transplanting something into a culture that is not used to having it is also dangerous.
Haley.
Yeah, I know I said I had nothing further to add, but I think it's important to pick up on something that Sir Jack alluded to in his responses.
Haley, could you speak slowly and very close to the microphone? It's hard to hear you.
Yeah, of course. I just wanted to pick up on something that Sir Jack said in his response to the comments by David and I, and it was a mention of the reforms in the Judicial Review and Courts Bill, which purports to, for those of you who are familiar with administrative law, reverse the decision in Upper Tribunal and revert to something we call pre-anismic jurisdictional error in administrative law, in terms of the ability of the High Court to entertain applications based on unappealable decisions of the upper tribunal. I think that's been a kind of widely debated potential change. Some people on, for example, legal social media have referred to it as very innocuous. I personally think it's quite dangerous and poses quite a risk to vulnerable persons. But I was wondering if Sir Jack was in a position to expand further on that part of his comment. Thanks.
Well, I think I'm going to 2 points. First of all, it was said, one of the justifications for getting rid of it was said to be that so few cases, if you look at the number of JR cases brought, there were a tiny number of cases where there was any error of law, reviewable error of law. I read somewhere in the last few days that those figures are not correct, and that if you look at the way you look at the figures, that's much larger. I think there is a problem if you have an area of law. Immigration is very often an area of law, and immigration involves a lot of court cases, where there are many, many cases where there are people who are desperate, who want to get their cases heard, and most of their cases are useless. And I see that. But if we look at the cases in the early 1950s, like the Medical Appeal Tribunal, Gilmore, and other cases then, Shaw, and the DPP in Head about detaining a mentally incapacitated person, these cases are cases in which bodies made errors of law. Maybe they were jurisdictional, maybe they were really important, maybe they weren't. And I grew up, I mean, anismic came out just before I did my final exam. So I grew up with error of law on the face of the record. I think that a robust permission filter for judicial review should mean that there is space for the aberrant decision to be controlled by the ordinary courts. I mean, in the book, I make some wonky points, which I don't know how much I believe in them. I say, well, a tribunal judge actually doesn't have the same security of tenure as a high court judge. If you look at the Courts and Tribunals Act, a tribunal judge is subject to the direction in many ways by the senior president of tribunals. The senior president of tribunals has been a distinguished senior judge, Robert Carnworth, Jeremy Sullivan, and others. But I do think that there is some virtue in the ordinary courts, where the jurisdiction is ultimately an inherent one. Whereas if you get rid of that, everything is down to the statute. And I think that there is a worry that we will lose a protection, and that if you do it for the cart type situation, you can do it for other situations too. You simply, you've got a formula that may not look very aggressive, which could create lots of, could balkanize our legal system. We could create law and equity and environmental, we could create lots of pockets of law. Now, actually, there are many liberal, good lawyers who thought, a friend of mine, Harry Arthur, spent a lot of time railing against the courts interfering on errors of law because they would impose their judicial view of it. Timothy and I have a slight difference on a case called South Yorkshire Buses, which was where I also think that we come quite close to having the American Chevron doctrine, because Lord Mustill says, well, there's only one meaning for the word, a substantial part of the country, to authorize a takeover and control of the commission. But he says it's such a fluid concept that we must apply the Edwards and Bairstow rule, that the courts won't intervene even in an error of law unless it's, or the result is one that no reasonable person could come to. I think that I see the fact that the homogenization of questions of law by courts imposing a single approach doesn't recognize the skills of specialist tribunals. But I still think that our judges, who are more generalist than many, have a role to play in this. And, you know, the very, very specialized areas in tribunals, sometimes they can go, you lose sight of the general principles. You're looking at the particular context, regardless of the broader issue. So I'm with you, Hayley, on that, I think.
Thank you, Jack. I was taught administrative law by Toronto labor lawyers, so it does have a lasting influence. Paul Craig has a question or comment.
Thank you very much indeed. Great pleasure to be here. And Jack, thank you very much for the excellent book and for taking part in this webinar seminar this evening on the book launch. Congratulations again. I just have a genuine question which arises concerning CART, given that this is on the table at the moment. And I really appreciate your views and the views of the other judges about this, because my sense about CART, or my surprise about CART, is as follows. It seemed to me that the actual reasoning and result in CART in the Supreme Court was in normative terms entirely sound. In other words, as we all know, what the Supreme Court did was to say that it rejected the idea that there should be no long stop judicial review of the upper tribunal in this kind of case. But at the same time, it recognized the expertise, the judicial nature of the adjudication by the upper tribunal and the first tier tribunal, and then carved out a more limited form of judicial review, which was subject to the two principles articulated clearly by the Supreme Court in that case. So my question then is that the approach taken by the government is predicated on the fact that there's been nonetheless a flood of CART JR applications, the success rate of which has been rather low. Question mark exactly what that figure is, but rather low. But my question is, and it's a genuine question, it's not rhetorical. My question is, given the criteria in CART articulated clearly in the Supreme Court, why was there such a flood? I mean, it seems to me, why could the court, as it were, in limine on a number of these cases, simply have said, you really get nowhere close to the criteria you're going to have to meet to succeed in this kind of JR application. Therefore, this case stops very much on the threshold of the court's door and doesn't go any further. So what am I missing here in that respect? I would value your thoughts. Thank you very much indeed.
There are other judges here, although one of them has just gone. I see Mike Fordham has gone. He'd know a lot about this. I think that many of these cases have been winnowed out. I remember when I was in the Court of Appeal, there was a period in which I had responsibility for dealing with some of the procedural matters to do with listing of cases. And you'd get, for example, we had, forget CART cases, we had hundreds and hundreds of cases about English language tests, when tests were being done and there were challenges to whether they'd got them right or wrong, and there were challenges to the integrity of the system, and people were being told they were failing the test and therefore they couldn't come to the country or stay in the country. They were testing, the whole thing was being done by AI. And one of the things that was done was to group together cases and get a whole load of claimants together. And I think that happened in immigration cases, in other sorts of immigration cases, the school cases when people got permission for them. So but there still were an awful lot of cases, and there was a feeling, I think there was a feeling that a lot of time was being spent doing rubbish, but actually, in a way, that's the court's responsibility, because you have to decide whether it is rubbish or not. And every so often, there will be something. There'll be something that will come up. So I don't understand. The answer to the question, Paul, is I was as irritated as many by the number of completely meritless cases that you have. And you have to be careful not to get yourself case hardened. But I do think that it's important for the system that somebody looks at these cases closely, because there are always some. But an overworked system may find it difficult to identify them.
Philip Sales.
Yeah, I was just wanting to, well, perhaps add something to that. I think that the short answer to Paul's question is that even though the test is to be applied for whether judicial review can be sought in such cases, a very severe test, it still requires a judge to look at the cases in order to see whether the test has been satisfied. So I don't hold a brief either to criticise or defend CART, but certainly when I was still a frontline judge in the administrative court, you would get very large numbers of CART-type cases. And it does have to be borne in mind that they've been looked at twice by the specialist tribunal, the first-tier tribunal and the upper tribunal. And CART cases arise in circumstances where both of them have said that there isn't an arguable case. Now, in a sense, their cases can always sneak through. The Supreme Court, sometimes doesn't give permission to appeal when it should do. So you're never going to have a legal system that completely eliminates the risk of error. But I think that there was a sense that if a case has been looked at twice and has been determined to be unarguable twice, that there does come a point at which a decision has to be made about allocation of judicial resources, because if judges are spending all their time looking at hopeless cases in order to say, no permission for judicial review in this case, in fact, that is diverting what was a fairly small cadre of judges doing that work from actually determining cases which were arguable and needed to be determined on the substance. So I think that's what lies behind it in answer to Paul's question. You can debate whether that's the right line or not.
Without even allowing Jack to comment, I want to bring in Stephen Sedley, particularly if it relates to this, and then we'll let Jack wrap up because we're going to finish very shortly. Stephen. Your computer is muted, Stephen.
Am I audible now?
Yes, I can hear you. Good.
There's a very brief intervention, if I may. The problem with CART was the Supreme Court was asking for trouble in its decision in CART. It's not surprising that Lord Fawkes gave them trouble. If you go back to what John Laws decided in the Divisional Court, when I decided upholding him in the Court of Appeal, I think we got it right. We said that the only review that was possible was on pre-admitted grounds, either total failure of fair hearing or a failure or an excessive jurisdiction in the classic sense. In other words, to try an issue that wasn't within their powers. If we stuck with that, I think we might have done better.
Thank you. If I could just comment, when we teach administrative law, that's one of the cases where we tell the students, don't just read the Supreme Court. You've got to read the Divisional Court and the Court of Appeal in CART. Now, Jack, we should wrap up. Can I hand it over to you and you can comment on this point or anything else, and then we'll conclude.
No, I just want to say how grateful I am that people have taken time to come and talk and think about all of this. My takeaway from this is still that I believe that the problems that we face are problems because we don't have an adequate way of checking the executive. And because my own feeling is, contrary to what you've said, Timothy, is that except when we have a very narrow majority or a hung parliament, which happens very rarely, the accountability of the executive to the elected chamber is very weak. So that is why I stay with my 1960s close on with Annis Minnick and Ridgeon Baldwin and those ones. I think they're really very, very important, and we mustn't unwind in the way that we might be doing to go further back. Well,
look, I wish Lord Reid and Lord Wilberforce could have been with us. Wouldn't they have enjoyed this, and wouldn't they appreciate your book and the picture it gives of what's gone on since the 1960s, and of course is going on. And look, much virtual applause from all of us, Jack. And I want to thank all the participants for joining us. It's good to see you all, and thank you very much. Thank you, Jack. And thank you to Hayley and to David.
Thank you, and bye.